Good morning.
Okay.
You're Marcus Elam,
Yes,
and Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
I do.
Are there any additions or corrections to the report?
No, nothing's substantial.
And it was unagreed. Mr. Lewis, you may.
In the halls of justice, second chances are not just ideals, they're lifelines. The courtroom is where redemption is weighed against responsibility, where hope often stands trial. And in this courtroom stands Marcus Elm, a young man who, not too long ago, was given an opportunity many only dream of, a chance to walk away from prison and build a better future under probation. But instead of progress, Marcus chose a different path. Within months, that opportunity turned into a checklist of poor decisions, burglary of a habitation, probation violations, and long periods of going completely off the radar. Now, after disappearing for an extended period, Marcus is back, this time, with a speech filled with sorrow, regret, and stories of personal loss. But the question before the court is deeper than emotion. Is this a sincere attempt at change? Or simply another chapter in a pattern of avoidance? The judge must now decide, has Marcus returned to take responsibility? Or to ask for one more chance he might not deserve?
Give him that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's being told on top of him. And of course, he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over and get life, live with my family, go back to work, till my mother died, live a bill, and everything else, Your Honor.
Okay.
As the proceedings begin, a familiar defense takes shape, the one we've all heard: yes, I made mistakes, but I've changed now. Marcus's attorney begins crafting a narrative of transformation, of a man who was overwhelmed, lost someone dear, and made poor decisions under emotional strain. He tells the court that Marcus is now ready, that he's willing to do what's right. But there's a catch: Marcus didn't come back voluntarily. He was arrested. His return wasn't a decision, it was an obligation forced by law. And then, the courtroom hears about a tragedy: Marcus's grandmother passed away. It's presented as the tipping point for his disappearance, a reason for why everything spiraled. But the reality remains: many grieve, yet most don't respond by evading probation and accumulating new criminal charges. This isn't about denying pain. It's about whether that pain justifies unlawful choices, and whether grief can truly excuse years of dangerous behavior.
My understanding, Judge, he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
And he pled true to the deadly conduct discharging a firearm from August 16th of 2023. Anna, can you tell?
I'm sorry, Judge, I didn't look him up after he pled through.
I know, I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
Gave an obstruction in 2023 that was dismissed.
Birthday judgment. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that.
In the face of mounting legal trouble, the court turns to one particularly alarming moment: a deadly conduct charge. When asked about the details, no one seems to have clear answers. There's confusion, hesitation, even among those expected to know, but the facts are documented. Marcus fired a weapon during an incident, fled the scene, and failed to identify himself when caught. These aren't minor oversights, they're serious actions, all while under active probation. He pleaded guilty to a gun-related charge. And yet the defense treats it as though it's a small procedural bump. This isn't about forgetting a court date, this is a direct breach of public safety and trust. The judge must now consider, When does repeated criminal behavior stop being seen as a series of mistakes and start being recognized for what it really is, a refusal to change?
Standard of having committed all of those new offenses while on probation, although he has no felony convictions. It looks to me like you ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they would take him.
I think when he had the prior NTRP, I don't know if it was at the new case or a prior NTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral reclamation therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
You get an opportunity to be on probation for a burglary of a habitation.
The prosecution lays it out. Marcus Elm was not just non-compliant, he was completely unreachable for nearly 2 years. That's not just skipping an appointment, that's vanishing from the system entirely. No check-ins. No updates. Nothing. In that time, he racked up more charges: deadly conduct, assault, evasion. He missed court-ordered rehab and other critical programs. When asked why, the answer is unclear. Sometimes it's grief. Sometimes it's confusion, but the reality remains, Marcus had multiple chances to get back on track, and each one was ignored. If this level of absence and escalation is described as trying, then the court is forced to ask, what would not trying look like?
So you get deferred probation for burglary of a habitation, second-degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on that day, right?
Mm-hmm.
So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you?
There's a tone shift in the courtroom now. The judge, usually composed and calm, is clearly struggling to maintain patience. Marcus openly admits to firing a weapon while on probation and then being arrested again. This isn't a game. You don't get to start over every time you say I'm sorry. And yet, Marcus repeats those words like a chorus, as if repetition can substitute for accountability. The judge listens, carefully, but with growing disbelief. He's already had multiple chances. Each time he was offered help, he stepped further away, and now he returns, not with completed programs or proof of change, but with apologies and explanations. At some point, the system has to decide, how many times can someone break the rules and still be trusted to change?
For the young people to keep coming in here with offenses that have to do with shooting while you're on probation for a felony. You're shooting. Then you get out again and you violate again and you take off. So I can't give you a 4th shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation.
This is more than a courtroom drama. It's a human tragedy unfolding in real time. Marcus Elm was just 19 when this journey began. Today, at 23, he stands on the brink of a much longer sentence, 6 years behind bars. The court had hope for him. The judge, the attorneys, even the probation department, they tried. Over and over again, they reached out with lifelines, offering help, rehabilitation, and second chances. But instead of grabbing hold, Marcus chose to run. Now, as the judge prepares to read the sentence, there's no joy in the room. Only silence. This isn't justice celebrating a victory, it's a somber moment acknowledging that sometimes, despite every effort, change never comes.
Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis.
And now, the final chapter, 6 years in prison. That's the time Marcus Elm will serve for his choices. It's a verdict not made in anger, but in exhaustion. The judge delivers it with clarity: no more weapons, no more missed appointments, no more chances. Even now, the system remains fair. Marcus is handed a document outlining his rights. His dignity is preserved, even as his freedom is taken. That's the law's promise: fairness, even when fairness hasn't been returned. So here's the question the courtroom leaves behind. If Marcus wasn't Marcus, if he had a different name, a different background, would he have received so many chances? And if he had, would he have used them any differently?